Welcome to the WRAL Daily Download. I'm Jack Hagel. On Wednesday, the U.S. Supreme Court will hear arguments in a high-profile case that started here in North Carolina. At its core, it's focused on voting districts in the state. But legal experts say the court's ruling could have a broad impact across the country, everything from how elections are run and checks and balances in state governments. The case is Moore v. Harper, and in a series of episodes this week, we'll be digging into it. Today, we're joined by WRAL state government reporter Travis Fain, who's been following the case. He's here to give us an overview. Travis, welcome.
Yeah, thanks for having me.
Travis, let's go back in time. This case started out as a state case called Harper v. Hall. Who's who in that case, and what's it all about?
So Harper is a voter named Rebecca Harper here in North Carolina, and she is represented by some national level attorneys, left-leaning, backing Democrats, trying to get redistricting form in the state. There are also a couple of other groups. There's so many lawyers in this case, my goodness. And then Hall is a state representative who helped draw the maps in North Carolina. The case was about the last round of redistricting. So the state legislature every 10 years after a census draws new maps, 2 state legislative maps for the House and Senate, and then 1 for the U.S. House of Representatives. And that's how we know what congressional district we're in, for example. That's always a fight. Republicans control the General Assembly. They drew the maps they wanted. Democrats, left-leaning groups sued and said, nah, these are gerrymanders. You're trying to lock in control. You're trying to lock in power, and that's not legal under the state constitution. So this went all the way up to the state Supreme Court. State Supreme Court agreed, redrew the congressional map, made the legislature redraw the House and Senate maps, and basically where the case is now is it's flipped, because now Moore, that's Tim Moore, Speaker of the House, is suing Harper, the original plaintiff, in the United States Supreme Court. And the argument is that state Supreme Courts do not have the power to rein in state legislatures when it comes to drawing congressional maps specifically.
What are the issues that justices are going to be examining?
So there is in the United States Constitution something called the Elections Clause, and it says more or less that state legislatures will set the time and manner of elections for Congress, for federal elections. And what Tim Moore and other Republicans are arguing here is that, well, that means because the U.S. Constitution lays out this power specifically for state legislatures. It says legislatures, and it says that Congress can change what the legislatures can do, but it doesn't say that state-level courts can change what the legislature does. So they say, hey, when it comes to writing the rules, including redistricting, for federal elections, that is the prerogative of state legislatures without the ability of the state courts to step in and say, no, this violates state law, this violates the state constitution. So basically, the whole rigmarole of our redistricting as relates to the congressional map shouldn't even have happened because state courts don't have authority there.
So what are the key arguments on each side? And I understand that one side thinks that this could mean a lot more than what the other side thinks.
So the argument for the Republicans is kind of what I just laid out there. It's as simple as, hey, the U.S. Constitution says state legislatures do this. The other side is, well, for 200 years, state courts have been exercising authority over state legislatures, reining them in when they need to be. There is no need, because you guys are misunderstanding what the United States Constitution really means, to overturn all these decades of precedent. The argument also being that, a lot of things are delegated in the United States Constitution to Congress, right? But that does not mean that the federal courts, including the United States Supreme Court, can't overturn an unconstitutional law that Congress passes. So why would you read into this Constitution, the U.S. Constitution, that state courts cannot overturn what a state legislature does, even if it deals with elections? So that's kind of the other side of that coin. One says it's really simple, just read the Constitution, it gives us this power. And the other side says, yes, but you don't have unfettered power. There is always the check of the courts. That is how the Founding Fathers set it up. And that's what everybody thought it was until y'all came along and started making this argument.
So at a high level, then, what's at stake here?
So definitely control whether or not the state courts can check state legislatures when it comes to election laws surrounding federal elections, so House, Senate elections. So definitely redistricting. Voter ID laws in federal elections, that would be an issue. How long we accept absentee ballots and how mail-in voting is handled. That's something that we've fought over in North Carolina and in other states that the courts have been involved. The question is whether it goes any further than that, how this case, if the Supreme Court decides with Republicans on it, could be interpreted going forward. There are some people who will tell you there is an underlying theory here called the independent state legislature theory, and that is what we've been talking about here, where only the legislature has the power to do these things with federal election law. So that was part of arguments that some Trump supporters, some of his attorneys made, President Donald Trump, of course, in the 2020 elections, right after the 2020 elections, basically saying, well, we want Republican-controlled state legislatures to subvert the election. We don't think Joe Biden won this, and so we want Republican lawmakers in these handful of states that are controlled by Republicans where Biden won to name their own electors. I mean, this gets kind of deep because we don't vote for a president in this country. We vote for electors that go to the Electoral College, and then they actually elect the president. So what if states try to do their own slate of electors and kind of subvert the will of the people? Does a ruling in this case give them the power to do that? Or does it at least give that strategy, which was part, we've got history here. It was part of the Trump 2020 post-election strategy. Does this case potentially give that strategy a leg up? That's a big concern. It's not written into the briefs. Like if you read the briefs, you're not really going to see an argument about presidential electors, but it's something that people kind of worry that they see coming around the bend in this case, beyond its major impacts into redistricting, because redistricting goes a long way toward deciding who wins elections.
It really all comes down to how narrow the ruling is. What happens if the Republican leaders prevail, or let's flip that around, if the voting groups win?
So if the voting groups win here, then state courts in North Carolina and in the rest of the country would feel empowered to second-guess decisions that legislatures make when it comes to voter ID laws, absentee ballot laws, any sort of voting law, redistricting. If a state court wants to say, hey, partisan gerrymandering is illegal under our state constitution, then they would have that power to do that, which is what happened here in North Carolina this past cycle. If the Republicans win, then it would just be whatever legislatures say. Those are the rules of a federal election. And I'm saying federal election because that's what the U.S. Constitution speaks to, those elections at the federal level as opposed to a state legislative election or a county commission election. We could even have kind of two sets of rules potentially because of that dichotomy, right? Because of what the U.S. Constitution says and doesn't say. So if Republicans win out here, then what they have seen as activist judges meddling in state election laws would go away, because they will argue that, hey, look, the state legislature is closest to the people. We're accountable to the people. The U.S. Constitution empowers us to make these decisions. We need to be able to make these decisions without the court stepping in and reversing what we have done.
Let's take a quick break. When we come back, we'll talk about what to watch for on Wednesday when lawyers argue before the Supreme Court. Welcome back to the WRAL Daily Download. We're talking with WRAL state government reporter Travis Fain about the Moore v. Harper case that will be argued before the U.S. Supreme Court. Travis, you've covered a few Supreme Court cases. When you cover these arguments, what is it that you're listening for?
Well, hopefully in this case, a good summation of all the arguments. The case file here is really, really large, just dozens of briefs from people all around the country who are interested in this case for kind of reasons we've discussed. It's a big, big deal. And oral arguments that, they tend to sift through that. They tend to clarify that. The attorneys and the justices themselves. I don't know if for people who have not listened to a Supreme Court or any high court, it's fascinating to listen to the lawyers get up there and start this thing that they've worked so hard on, this opening statement, and then two sentences in, a justice interrupts them with a question, and they just have to throw all that out. So you listen for the justices' questions, and you try to get a sense of, all right, well, this justice really questioned this lawyer really hard on this issue. That must be key. And maybe they're leaning this way or that. So there are people who follow the Supreme Court closely who are better at this than I, but it's really difficult to guess which way the court is going to go based on the questions. But that's something that we all do, is listen to the questions kind of as a roadmap to what the justices themselves are thinking and what they think are the important points.
You mentioned the outside groups in this case. There have been a ton of amicus briefs filed. Tell us about those. What are they arguing on each side?
So an amicus brief, a friend of the court brief, basically this is someone who's not directly involved in the case, but they think they have an interest in it, and they say to the court, hey, we'd like to be heard here. For example, different legislatures around the country, or I don't know of any that are specifically involved, but legislators who are in positions around the country have filed some amicus briefs. Justices on state Supreme Courts from around the country who see perhaps their authority about to get reined in, they've filed in this. So different people with different interests have filed in. It's more than I care to count, honestly, that have been filed in this case. I don't know that I've seen this many in a case. I mean, it kind of speaks to the importance that people are attaching to this, that we've seen so many amicus briefs.
One amicus brief in particular stood out to you, and you described it in your article on Sunday. Tell us about that.
Yeah, there's a guy named Derek Muller at the University of Iowa. He's a law professor up there, and he has followed this pretty closely. And he basically gave what I kind of think of as an escape hatch to the Supreme Court. If it doesn't want to deal with the constitutional issue here, or at least not deal with it directly, what he argues is that, so we talked about how state legislatures and Congress are empowered by the United States Constitution to set federal election rules. He says Congress has already done that, and the way Congress has done that in the U.S. codes of federal law allows state legislatures to then kind of piggyback off of that, and state government, rather, to piggyback off of that, which empowers the courts to review what state legislatures do. So I kind of see this as a way, if the Supreme Court cannot find, enough justices cannot come together to form a majority to decide this case, the way the Republicans who have brought it want it, or the way the opponents to that argument want it. This kind of lets them split the middle there and just say, oh, okay, well, Congress has already handled this, and everything can just flow from there. So like I said, it's an example of a more narrow ruling that would be less impactful. And one of the things when I talked to Mueller about his brief that he brought up that I thought was really interesting is he said, that the court could say, all right, well, North Carolina's state Supreme Court relied on some relatively vague language in the North Carolina state constitution to make its decision. The Supreme Court, the U.S. Supreme Court, could say, no, you can't do that. That's too vague. But states that have more specific language in their state constitutions, that's okay. So that's just an example of how this ruling could be less impactful nationwide, depending on how the U.S. Supreme Court goes.
So what happens after Wednesday?
Basically, we wait. We wait to see what the Supreme Court has to say. That could take a while. A lot of times it takes months for these opinions to come out, of course. So we just kind of wait, and people pontificate on what they think the court will do, and then the court will actually do what it does. And I would caution people when these things come out, these decisions are announced, you got to read these things carefully. You got to be careful about kind of initially saying, well, this is what this means. We've talked about how narrow or broad this decision could be. They could say, all right, well, you know what? You're right, North Carolina Republicans, and you do have a sole right to redistrict as you please without input from state courts. The question is, do they go further than that? How does the language get used in future court cases? Because we're never done fighting over these things in lawsuits. How does that language get used? How far can it be pushed? How far can people who want this or that or the other, how far can they make an argument based on what comes out here?
I'm wondering, Travis, North Carolina just elected a Republican majority Supreme Court. You've got a strong Republican leadership in the state Senate and the state House. Does it even matter what happens next? I mean, they're going to have control, and in theory, they could be in alignment on a lot of issues. Does it even matter in the state in the near term?
Well, I think you're right in that you would expect a Republican-controlled Supreme Court to give a lot more deference to what the General Assembly wants to do on gerrymandering, to potentially even allow partisan gerrymandering. There have been some Republican opinions written from the court where they just did not like what the former Democratic majority did in this case specifically and in past cases. But, the precedent that's going to be set here will be set nationwide. And who knows who's going to control the General Assembly in North Carolina in 10, 20, 30 years? Who knows who's going to control which party will have the most seats on the state Supreme Court? So, it matters a great deal going forward. And it also matters a lot when we just talk about what the ground rules are for redistricting, this supposed to be once a decade process that we go through to draw fair, if people even want it to be fair, election lines, to draw lines by which we elect our leadership. There was a case called Rucho, also out of North Carolina, that was before the U.S. Supreme Court several years ago at this point. And basically the U.S. Supreme Court said, this is not something partisan gerrymandering that we're going to rein in at the federal level. We're just not going to do it. But you're not necessarily shouting into the void, the court said, about partisan gerrymandering. It's not necessarily a good thing that politicians draw lines in order to save power for themselves and their party. You can turn to state courts and you can turn to state constitutions to rein in partisan gerrymandering. Well, that's exactly what happened in this case, is the folks that were arguing that case at the United States Supreme Court level said, okay, we can't block partisan gerrymandering there. Let's go back down to the state courts and do that. And if that avenue was also taken away just a few years after the Supreme Court itself said that was the avenue, that really opens the door for aggressive gerrymandering. It kind of puts the imprimatur of, you can do that.
Well, we'll look forward to seeing how it all plays out. Travis, thank you.
Thanks for having me.
That's WRAL State Government reporter Travis Fain. For his in-depth coverage of the Moore v. Harper case, visit the NC Capital section of WRAL.com. Tomorrow, we'll hear from people more closely involved in the case for their perspective on things. I hope you'll join us. And thanks for listening to the WRAL Daily Download. You can also listen to entire WRAL newscasts in podcast form. Search WRAL Newscasts in your podcast app. The feed is updated with new newscasts multiple times per day.